This is cause number CR 23-163, State of Texas versus John Henry Johnson. Mr. Johnson, sir, you'll raise your right hand. I'm going to place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
All right, thank you. You can lower your hands. All right, your name is John Henry Johnson, is that correct?
Yes, sir.
And Mr. Johnson, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work he's done for you as your attorney?
Yes, sir.
Do you have any questions about the paperwork or your case or anything else before we go forward?
No, sir.
Okay. Mr. Manning, do you believe your client, Mr. Johnson, to be competent?
He is, Judge. During the course of our representation and in preparation for trial, he was able to sit down with me, interact with the discovery, prepare defenses, engage in conversation regarding his case. And I believe his waiver of those defenses and his entering into a plea today is done intentionally, knowingly, and voluntarily.
Thank you, Mr. Manning. All right, Mr. Johnson, you were originally indicted by the grand jury with a second-degree felony offense of aggravated assault with a deadly weapon. I see today that the plea agreement between you and the DA's office is they're recommending that the court consider the evidence and allow you to plead guilty to a lesser included offense, a lower offense of a Class A assault causes bodily injury. They're recommending that your punishment be assessed at 97 days in the county jail, with you receiving credit for that 97 days that you've already served. In addition, they're recommending a $250 fine. The range of punishment for a Class A misdemeanor is confinement in the county jail for not more than 365 days and a fine not more than $4,000. Understanding the plea agreement and the range of punishment, Mr. Johnston, I would ask you, how do you plead to the Class A misdemeanor offense of assault causes bodily injury?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anybody threatened you, forced you, or pressured you to plead guilty?
No.
Court does accept the defendant's plea of guilt at this time. Mr. Manning, any objection to the stipulation of evidence?
No objection as offered, Judge.
All right, the stipulation of evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, only that state is in compliance with victim contact, but victim impact statement was sent out and not returned.
All right, thank you, Mr. Harwell. Anything further from the defense?
Nothing from defense, Judge.
All right, I do have a question. I think his original indictment included a deadly weapon allegation. I don't see any kind of weapon disposition in this plea. I know that the whichever agency is holding this weapon is going to be inquiring about whether or not they're to return it. Is there an agreement on that?
Your Honor, I believe the weapon actually belonged to a co-defendant, and I believe the disposition was in that case.
Okay.
I can double check though, and if a nunk is going to be required, we can probably work that out.
Do you know who the co-defendant is?
I can look it up real quick, Your Honor.
Judge, if I may, actually, I believe at least one of the seized items was, in fact, my client's. And our understanding was that it was going to be returned to him at the disposition of this case. I've explained to him the policy of the sheriff's office that he has 30 days from this time of judgment to go pick up his property. Additionally, Judge, there was a truck that was on Mr. Johnson's property that was seized as evidence as part of this case. I've been unable to track down that disposition, but I've told him that once the case is complete, he can take the paperwork to the sheriff's office and request receipt of those items.
Okay. All right, court at this time is going to review the evidence. All right, court finds that there is enough evidence to convict Mr. Johnson of this offense. The court will follow the plea agreement. Court hereby convicts John Henry Johnson of Class A misdemeanor assault causes bodily injury, assesses his punishment at 97 days confinement in the county jail, issues him credit for 97 days time served, orders him to pay a $250 fine, $270 court cost, $535 in reimbursement fees. Mr. Johnson, are you going to be able to pay those financial obligations today, or are you going to need a payment plan?
Judge, if I may, he has credit for $800 based on his very regular pretrial payments. And so I did confirm that on the court cost sheet, he does have $800 credit. Miss Peggy said she will get with him after court to discuss settling out the remainder of the balance.
Okay, so he'll have about
About two
$265 credit towards $520.
I think he'll have about 200 remaining, 250 remaining.
Well, his reimbursement fees alone are $535, so that's the majority of that's gonna be taken out by that, so that's only gonna leave him $265 left, and then he'll have $250 fine and a $270 court cost, so he'll have $520.
Judge, as I said, I think Miss Peggy was able to provide the court cost sheet, and I think once we complete court, she's gonna apply those credits and
Okay.
talk about those remaining balance.
Mr. Johnson, you hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted with Deputy Martinez. And then if you want to stick around, we'll give you a copy of this for your records. Toronto, are you ready? Come on up. This is cause number CR 24218, State versus Isaiah Alexander Madrano. Court has set Mr. Madrano for arraignment today on the charge of evading arrest or detention with a vehicle, a third-degree felony. Court has found that Mr. Madrano is indigent on his application for court-appointed counsel. Court finds him to be indigent for the purposes of the Sixth Amendment, has appointed Honorable Jonathan Manning as counsel. Mr. Manning, are you ready for arraignment?
Yes, Judge, we have had an opportunity to go over the indictment. My client's name is spelled correctly. He understands the charge against him as well as the range of punishment. At this point in time, pleads not guilty and requests to be set on the pretrial docket.
All right, the court does enter Mr. Madrano's plea of not guilty into the record. Finds that he does waive the formal requirements of arraignment. Court sets this matter for a pretrial hearing.